Thank you, Lisa, for the introductions. And hi, everyone, tonight. I'm excited to get started. So a prenuptial agreement is a private contract contracted by two parties that intend to get married. It is not enforceable, or I'm sorry, it is not valid until the parties get married. So you actually have to get married and you have to create it prior to marriage. And it allows you to delineate what property, premarital property, you want to keep premarital or you want to keep separate, and what property that may be accrued after marriage you want to keep separate or you want to be marital. And this is really important and depends on what state you're in largely. Some states have community property, some states have marital property. It also allows you to kind of life planning, right? Do you want to travel? Do you want to retire at a certain age? And the reason these conversations, life conversations, are so important when we talk about a prenup is because those life choices will be dictated by how much money you have to do them, right? So those premarital, or I'm sorry, I keep calling them premarital, those separate assets versus those marital or community assets are going to be really important for you to understand. And again, a prenup, and I always stress this because it's a very common question, is does it have to be signed prior to marriage? Yes. If you miss the date to sign your prenup, and I don't know where everyone is coming from today, maybe some of you are in California, where there are requirements that you sign a prenup before, I'm sorry, you have to have the final agreement 7 days before signing, which limits you on when you can finalize your prenup prior to your wedding. But if you do miss that cutoff, then we're talking about a postnup. Postnups are similar to prenups in that they allow you to contract away certain rights and contract to how you want to hold certain assets in the event of a divorce. But postnups are a little bit more complex. They're newer. I call them the prenups of like 15 years ago. Courts have a harder time or more resistant to enforcing them, especially when the terms are very stringent or lopsided to one party, because the courts understand that there's this kind of unequal bargaining power that can come into play in a marriage. And so certain states will only allow you to contract certain things. Certain states will I do not favor postnups at all. So I always say, don't look at a postnup as, some easy, foolproof way to move forward with a prenup just because you ran out of time. If you have the option to do a prenup, do a prenup. But they're generally less enforced, but can still be very valuable when you are in a marriage where things may feel uncomfortable or financial conversations may come up that you want to ensure are sorted out. A postnup can help you work through those issues and continue on in your marriage.
Now, I'm going to say in New York, and I'm not talking about any other state, in New York, postnups are enforceable. And although you have to show consideration, and so you want to make sure you have that back and forth. But in New York, there is definitely a favorability to enforcing contracts that people enter into on their own. And so many postnups are enforced. It's rare, actually, in New York that a postnup will be set aside unless it wasn't done properly or properly acknowledged. So in New York, you can feel pretty safe entering into a postnup. I think that the big issue, and maybe Julia, you can shed some light on this, is when somebody approaches you for that postnup, are they approaching you because, and I think that this is the key, are they approaching you because they want to have this roadmap for the future, but are really intending to stay married? Or are they approaching you for other reasons? Maybe you could speak to that issue, Julia.
Yeah, so there's something called divorce planning, and probate judges, divorce judges do not like it. And in Massachusetts, actually, a postnup will not be enforceable, period, end of story, if it was created in contemplation of a divorce. How do you show that? It's a little bit difficult, but timing itself can show that, right? Actions themselves can show that. And so because of that, I think in order to ensure the best likelihood of enforcement of a postnup, both parties really do need to be on the same page. It really does need to be an effort to help improve their marriage versus, it's very clear when one party is the one who requested the postnup. Once the postnup is signed, they file for divorce, 3 weeks later. Everybody knows what they're doing.
And we've seen that. So, that brings me, Amy, to you, because we have seen more and more, I would say in the last 5 years, cases where there are trusts that have been formed, where parties have convinced one spouse to or maybe not even had the conversation, but just done it, okay, to move marital funds into a trust for the benefit of the children. And the problem with that, of course, is that it's no longer for the benefit of the spouse. And all of a sudden, people are served with divorce papers. And now there's, and I'm just using this as an example, there's either 1 million or 10 million or $20 million now in a trust. And I really am starting to count many cases that we're seeing more and more of this. So how do you deal with the issue when people come to you as a married couple to place monies in a trust? What do you do?
So that's a good question. First of all, you have to make sure you're representing both spouses, if in fact you are representing both spouses. So I often see that one spouse, not by me, but that one spouse is actually being represented. Like I've seen particularly, I'm going to say the husband being represented and the wife having very restrictive language in his document for her benefit. And like, it doesn't matter if the same is reciprocal or not, because she doesn't really have assets. And maybe that's a step better than giving all the assets to the children. But I think as the attorney, you really need to be very, very careful. And as a client, if you're sitting there with an attorney, the attorney should be representing both parties. And I've had parties leave representations because it's pretty obvious that the attorney is only speaking to one party. So if you are in fact in that situation, I think you should always say, like, what benefit is this, for me? Like, how am I being represented here is the main question. Because once you sign a trust agreement and agree to assets being put in trust for your children, that's going to be hard pressed to be undone. You signed it. I mean, unless you were somehow fooled, now oftentimes you have minor children and their interest is going to be preserved.
And how does someone know when they are being actually represented? And I'm going to say this happens so many times with trust and estates attorneys, with mediators, with lawyers, how does somebody know, Amy, when they can feel safe that they are being represented by counsel if they're going there with their spouse and their spouse found the person, except how do they know this? What do they need to ask?
I think it's a fair question to ask. As I said, please explain to me how this benefits me, you can say how this benefits me, how this benefits my spouse, how this benefits my children, but I would ask the question. I would say oftentimes when people end up switching counsel to me, that they say to me, like when I asked a question of the attorney, he looked at me like I was an idiot, or he answered very briefly and abruptly. And when my husband asked the question, it was like a law, he looked at him, it was a thoughtful answer. So I think I almost want to say sometimes even a gut sense of someone's not listening to you is probably right on.
And I remember years ago going to a trust and estates attorney, and I remember that she said to myself and my husband, I will not communicate with either of you without the other person being part of the communication. And because I do not want either one of you to feel that I'm not representing both of you. And she was very clear. She said, I will not make any changes to any documents. I will not communicate by phone or by email or any other way without making sure that you're both on it and that you both approve and that you both understand it. And that made me feel very secure with that particular person. So I think it's really important that you feel that way, that you're not just being taken to some room to sign some document. As we hear the stories over and over again, that's what's happening. And Julia, talk to us about how that is similar and in terms of prenups and postnups, because we also see that happen as well.
Yeah, I think it's kind of the unfortunate reality that prenups have historically been older men marrying younger women and requesting a prenup. And you see the women just kind of, oh yeah, I'll just sign here. I don't care what I'm signing. I think although that is the past, prenups are very different today. I think it is still really common where one party feels like they are not a part of the negotiation. And you take a very typical prenup negotiation between attorneys. And the wealthier party is usually the one who is hiring the lawyer. Sometimes the wealthier party is actually paying for the other side's, their fiance's attorney as well. And so what will happen is that party A, attorney A, wealthier party, will be the one to draft the agreement. That fully formed draft will then be given to party B to review and make edits to. This process, I think, inherently is a power dynamic issue, because what happens is the wealthier, more moneyed party has all of the power. They decided the initial terms. They put together the draft. They're paying for your lawyer. So now you feel like, okay, I can't really negotiate too much against this, or I shouldn't. I don't want it to cost too much. I don't want to make them too upset. That's why with HelloPrenup, and this is not an ad for HelloPrenup, but this is something that's very important to me, why with HelloPrenup, we have a dual participation system. So there is no draft until both parties have input all of the information regarding themselves, their desires for the agreement, and then jointly, as a couple, worked through the issues that they have in that agreement before they output a draft. Of course, hiring attorneys at any point during that negotiation, but the attorneys are only there to help them, not to, put together this 35-page prenup and then lob it onto their partner before their partner has a chance to even give any input. Negotiation between the parties in a prenup is very important. And I always say that. When I was a practicing attorney, I would always say, people would ask, how long is this going to take me? Like, I just want you to draft it. I want you to send it to my partner's attorney, and I want to sign it and be done. And I would always say, but the negotiation is incredibly important, because what you want to be able to show in the future for enforcement purposes is that draft bounced back and forth, right? You want to be able to show that both parties participated in the negotiation. This is the same with postnups. In postnups is probably even more important that there is some evidence of that draft bouncing back and forth, because what you don't want to happen is for one party down the road to say, oh, I had no idea what I was signing. I just signed on the dotted line. So I think the sentiment behind prenups and postnups this day and age is that both parties should be involved in the negotiation. You should never be signing something that you don't feel like you participated in, because this document, this prenup, is meant to protect you too. This is not just meant to protect the wealthier party, right? Both parties should be protected.
So I'm going to come back to you on that issue. But before I do, Julia, I want to talk to Lauren and talk to her about the negotiation of the prenup, because I think that it's your experience, Lauren, is so important, but it's also important to understand how you need to think about it even as you're negotiating a divorce or negotiating anything in your life. So can you tell us what that was like?
Yeah, absolutely. Hi, everyone. I'm Lauren. I'm the Chief Marketing Officer at HelloPrenup, but I am also a living, breathing case of exactly what Julia just described. So a little background on me: I got married to a much wealthier man. He paid for my attorney. He paid for his attorney. And I was basically what I felt like served a prenup, because it was under that same power dynamic. And basically what happens in that situation is you are absolutely negotiating with not only the person that you're about to spend the rest of your life with, and you're planning all these wonderful, blissful things about your future, but you're truly negotiating. And that term is really cringy for me, but it's the truth of the process, because what it should be is a collaboration. So one thing you said, Amy, that I really, really love is a great question of, how does this serve me? Because traditionally, we understand exactly how it's going to serve the wealthier party. But what's never truly understood in that power dynamic process is, how is it going to serve the less wealthy party? So one thing I try to educate people on that are going through this process is, you're not being served a prenup. You have equal rights in this process to speak up about what's important to you. And really, if it does ever feel like it's a negotiation where you're highlighting every word and sitting at the dinner table and about to throw a fork across the way of, why did you include this clause that says that I won't get any alimony in the event of a divorce or whatever, that's your moment to just say, how does this serve me too? So one thing that I really took away from that process, Lisa, is it's a collaboration. And if it ever doesn't feel that way, you want to make sure that if you are doing it with an attorney, that they are as thoughtful as somebody like Julia and Amy, who are sitting there and saying, this is a good reason to do this for you because, or here's another way to think about it. What if we consider this language instead, and we can counter back with this, so it feels more collaborative and less like you are being served this agreement in this clause. So I hope that was helpful, Lisa.
It was. And I'm just going to say, there's some great questions in the chat right now. I'm not going to have them answered right at the moment, but I promise to leave time for the questions that are already in the chat, because I think that they're very applicable to our discussion. So just stay with it, and we will get to that. Amy, I want to ask you a question. So there is now this, and this goes back to the issue of the trust. There is now a tax, I believe it's called a tax exemption, that is expiring essentially, or that will be terminating in the near future. And you and I were discussing this actually last night. Can you explain to us what that is and how people should start to approach it?
So we have a federal estate tax exemption. Each state, some states do and some states don't, in addition to the federal, but we're all the United States of America still. So we're going to talk about the federal exemption. Currently, that's a very high number. It's $13.61 million. So I will have people say to me, I don't need to worry about it. Like, this is just beyond anything that could possibly touch me. I don't need to talk about taxes. So number one, make sure you're not in a state that has a lower exemption, such as New York, where you should be talking about it. And number two, my next question to clients is, do you think you're going to live until 2026? Because that's when we call it a sunset. So the estate tax exemption as it is now, it continues to go up and up. And then at the end of 2025, it sunsets. In 2026, the exemption is 5 million indexed for inflation. So we do have inflation. So I don't know if that number is 6 million or 7 million. The point being, it's certainly not, approaching 14 million. It's getting sliced at least in half. And if you are below that amount, there is no federal estate tax. And if you're above that amount, it's a 40% tax. So there's planning around that.
So, okay. So just so I understand. So right now, if you're in, I guess, in New York or one of the states of the United States, there would be an exemption that you could give tax-free to your children, correct? Or to anybody, I guess, right?
So generally speaking, it should certainly be mentioned here that if you have a U.S. citizen spouse, you have an unlimited marital deduction, which in plain English means there is no tax on assets you give to your spouse, whether that's $1, $1 million, or $1 billion. That's not a taxable event, but it is a tax deferred event because eventually it goes to someone else and there is a tax.
And so when we are talking about, and this is what many women are faced with, somebody comes to them, usually their spouse, right? And says, we need to actually move all these assets and they're saying it more and more often now. We need to move all of these assets into a trust to benefit our children, so that there are no tax ramifications and our children are not going to be paying this huge tax. And let's just say it's above the tax exemption. So I'm just going to use the example. If it's a $5 million tax exemption, they can move up to $5 million as a gift up to the children, correct? And then anything over that, there will be a tax on that. Did I just say that accurately?
That's correct. It's an accumulated during life gift and estate tax exemption. So whatever you give during life, if there is a remainder at death, you have that, and then it's taxed.
So the problem, as I see it, because we, as I said, we've had this many times, is that once you do this, you have to do it in what's called an irrevocable manner, meaning you can't change your mind. And so sometimes somebody will come to you, a spouse, and say, let's move this money into the, into a trust for the children, for the benefit of the children, so that we're not losing all our money in terms of taxes later, and the children aren't paying these taxes, but this person may be a bad actor. Is that, and so how does somebody deal with that?
So here's the interesting thing that not every attorney will bring up. I certainly do. You can use your estate tax exemption by putting it into an irrevocable trust, not just for the kids, but it can also be for your spouse. So the spouse, I'm going to say, is sort of the safety valve because they may need it. But also in the definition section, you can have that conversation. Does this survive divorce, or are you kicked out as a beneficiary upon divorce? So often with these big trusts, when I have these conversations, in this event, we say, actually, you're going to stay in because there's a lot of money here, and we agree that if we're going to move you out, there's not a whole lot of money left in the estate to provide for anyone. And if you have one spouse earning money or has considerably more assets, and the less wealthy spouse is stuck, that's not a great thing. So, it's an important provision.
And actually, when you see it lopsided, okay, so in other words, and we have cases like this where I see on one side, the one spouse, it's fine during the divorce, there's no issue, okay, and the other side, meaning probably the wife, in the event of a divorce, that person is no longer actually a beneficiary. That would be, to me, a trigger that says there's a problem here and that you might not be well represented. Do you agree with that?
I do. I think it needs to not only be explored, but explored in writing. So I am sometimes quite surprised when I take over a matter and I get the file and there's not one shred of paper talking about, an 8-figure transfer. So I think whether you're the attorney involved or you are the client, an explanation in words is lovely, but you want something that you can go back and look at so you know not only what you did, but why you did it. So when I do a big gifting trust, I do review both. I'm going to say whether it's Zoom, on the phone, in person, but I also always have a piece of paper that says this is what we did and why we did it.
And Julia, now I'm going to circle back to you because this was an important question that you raised slightly. A lot of women going through a divorce are really disadvantaged. They've either been the stay-at-home mom or the stay-at-home person, and they are going through their divorce and they have not been able to make the strides that perhaps their spouse has made, because they have devoted themselves to the family instead of their career. How is a prenup or a postnup an advantage for them if they actually enter into such an agreement?
Absolutely. So I always say every woman should have a prenup, because you are planning your exit package. And I got that term from you, Lisa. But I think a prenup can protect women because what tends to happen, and this is very typical, unfortunately, gender dynamics, but women are the ones who are most affected by changes in life. So women are the most affected by having children. There's something called the motherhood penalty, where basically as women's career trajectories go up, that's also the same period of time that they're having children and are usually knocked out of the workforce. So while they take a step back, right, that step may be 3 years, it may be 7 years, it may be much longer. Those are typically the intervals. Their husband's or spouse's career is kind of on a trajectory upwards. So there's no way to earn that time or money back. You unfortunately, even if you were to re-enter the workforce 10, 12 years later, you have to think about what are you entitled to under the law? The law really does not protect women. The amount of child support and alimony, that calculation may not be sufficient to support you and your children. So that's where a prenup comes in. And a prenup can protect women by not only contracting to certain things, like if we're married 3 years, then I get X number of dollars for that period of time. So you can do lump sum payments in intervals. You can also do something called an equalization clause, which says if at the time of divorce, the marital funds are X and the separate funds are X, then this amount has to be moved into the less moneyed party's account. So basically equalizing out the wealth between the parties. You can also dictate in the prenup that if one party plans to stay home, and you can put in provisions that say, if you work less than 25 hours, the wealthier party or the party that's working full-time needs to transfer X number of dollars into the non-working party's bank account. So I think for women, it's very important for you to have control of your own money. And I know Lauren can elaborate more on this, and I don't want to speak for her. But when Lauren and I first started working together, this was something that we talked about. And it's so imperative for women to have access to their own money, not only to feel powerful and in control of their own decisions, but to feel some kind of equalization of power in their marriage and equal bargaining power.
And Lauren, so I'm going to turn it over to you since Julia volunteered for you to talk about this. So can you tell us?
Yep, absolutely. So spoiler alert, all of that kind of happened to me. So I was served a prenup. It was very one-sided. It was lopsided. It basically says, everything is his, and in the event of a divorce, nothing is going to be mine. Well, when I signed my agreement, I was pregnant. We were planning to get married, and I didn't have an awesome attorney like Julia or Amy or Lisa to sit there and say, hey, wait a second. Are you going to stay home and raise that kid? Like, do you have a plan to quit your job? And mind you, I was 27. I think I was just entering the workforce. I didn't have much to my name. And so I'm about to literally forfeit my career earning years to raise this kid. And at the time, nobody had ever asked me that. And so I'm just sitting there thinking, oh, great, I'm going to marry this wealthy man. We're not going to get a divorce. He's going to take care of me. Everything's going to be fine. But spoiler alert, 2 years into it, I'm asking to spend money at Sephora. My kid needs diapers and I have to ask for money for that. There was no discussions of how are we going to split finances? Do I have my own money? Does he just hold the cards for everything? Our house that we live in, is my name going to go on that house? Even though our son that we brought into this world together is truly my responsibility to raise. And I've now, spoiler alert, quit my job. None of this was discussed. And so I completely agree with Julia. I wish HelloPrenup existed at the time, because I would have loved to have had the education to make those decisions. And instead of negotiate, spending months and months just like tirelessly going through every single clause and trying to understand what I'm being served over these drafts, and my attorney saying, have you reviewed it yet? Instead of, have you considered this yet? Was a process that we're trying to flip on its head with HelloPrenup, because had I have known that this was what was going to happen to me and that it was going to set a huge damper on our marriage, number one, I would have never married him. Number two, I would have at least had those conversations of, okay, now I at least have my exit plan that prepares me and my son so that when I do enter the workforce, I know exactly what's going to happen, where my kid and I are going to live, where healthcare is going to come from. I'm going to have my own Sephora money and I don't have to ask for it. But a lot of women don't know that that's the potential plan until they get too far into it. And the other thing that I've learned going through this process is if you don't make decisions on behalf of you now through education and learning, your government's going to make it for you. So I don't know about y'all, but I really like making my own decisions and controlling my own fate if I can. So I just encourage everybody to ask questions and make sure you are asking the question of how does this serve me, and really finding any resources you can to empower yourself with that knowledge so that you can always create that exit plan and have that money just in case you ever need it.
Yeah, I think that too many times people think that the prenup is only for the wealthy. And we get that question all the time, or only for people who have second marriages, or not for people who have second marriages. But the prenup is your opportunity, as Lauren and Julia said, and you're right, it sounds like my language anyway, to create that exit strategy and make sure that when you're when and if it comes time, that you know what you're going to actually be receiving, as opposed to essentially playing the gambling game and hoping for it. And it's important that you stand strong and that you negotiate a good prenup or postnup for yourself. And I think all too many times people just overlook it or don't think it's appropriate for them. Amy, talk to me about powers of attorney, healthcare proxies, all of those documents that people should be looking at as they're going through divorces, because they may have signed some of these documents prior to starting a divorce. And what do they need to do as they're going through the divorce, keeping in mind the automatic orders?
So do you want to speak to the automatic orders?
Sure. So let's first speak. It's a good idea. So when somebody commences an action in New York, and I don't know what the rules and Julia, you may know the rules in some of the other states, but in New York, there is something called a summons for divorce. And then there is an automatic order that is attached to it. That automatic order prevents you, allegedly, from making changes to beneficiaries for retirement plans, investment accounts, just about everything. Insurance, certainly health insurance, you need to be able to stay on your spouse's health insurance until usually the notice of entry of the divorce, actually the actual judgment of divorce. So there's a lot of prohibitions about things you can and cannot do. It's very important, by the way, that you read those prohibitions, because you can be held in contempt if you do not actually obey them. That being said, there are certain things that you can do that the automatic order does not restrict. And one of them is a healthcare proxy. So maybe you could explain what that is and how to deal with that first.
So to me, if you were even thinking about divorce, this might be a run and not walk. I'm often surprised how many years of sort of acrimony people go through pre-divorce, during divorce, and they have a healthcare proxy saying, if I'm unable to make my own healthcare decisions, the person I hate most in the world is in charge of advocating on my behalf. That is a document I would run out and change. I would revoke it. I would name almost anyone else to make those decisions. So again, a healthcare proxy, you're always in charge of making your own medical decisions. This says who is going to step in if you cannot do so. So that would be a very important document to change. Similarly, power of attorney is for financial affairs. It lives with you and it dies with you. And the power of attorney, generally people are naming their spouse, saying my spouse can go into my accounts and do whatever he or she wants. That is a document you would want to also revoke. The New York statute, you have to even if you do a new power of attorney, you have to specifically get in there and revoke the prior one. And so you'd want to do that. You'd want to make sure that you were working with an attorney who understood what that boilerplate was, because simply doing a new power of attorney does not revoke your prior powers of attorney unless you stick up your hand and write in it, yep, I'm revoking all those prior powers of attorney. And then you probably want to give it to the person and go, it's revoked. Because if they don't know it's revoked, they're not doing anything bad by, I mean, maybe they are because they have a fiduciary duty to act in your interest, but they could still go into various accounts. So you would then want to make sure that that power of attorney was linked to your accounts, so that if your spouse, your divorcing spouse went in there, that there's no way for any financial institution to know you've changed it unless you've submitted that document.
So I have another question. It's actually one of the questions in the chat. And so let's say that the trust has been created, and let's say it's irrevocable. And let's say that there is an imbalance of rights in the trust. There was one maybe created for one person, another created for the other person. They are different in what happens at the time of a divorce. It's clear, or could be clear, that there is divorce planning. What does somebody do about that? Is there a way to set aside that trust, or is it virtually impossible to set aside the trust? And then do you have to just hope for more equitable distribution, Amy?
I think it's virtually impossible to set aside that trust. I mean, I'm trying to think how you would do that, other than someone forged your signature, someone told you it said one thing when it said another, and somehow you didn't have the opportunity to read it or didn't understand it. You're looking at the attorney for malpractice because they told you the trust was one thing and it's actually another. All of those things are very, very, very difficult to do. And again, if we're talking about minor children benefiting, you're going to have a hard time getting a court to get in there and go, oh, we're going to take away X amount of dollars from minor children. I don't think it's going to happen. It also pits you against your children. I mean, it's tough.
And I would tend to agree with you. I think it's hard for the court to take the money from the minor children. We have seen some of these trusts being used to support the minor children in certain ways. And we have seen sometimes, rarely, but sometimes there's a larger equitable distribution to one spouse because of the imbalance of the trust. But once you have signed these documents, it is very difficult, if not impossible, to retract. And so you want to make sure that before you actually place this money into trust, that you have consulted with an attorney who you know for sure is watching your back, and not just your spouse's back at that point. Julia, there is a question in here. I have a net worth approaching 1 million. I'm not yet married, but I want to prepare, especially if I have a higher net worth. What things should I consider as I prepare a prenup? I want to be fair to my future spouse and also protect myself in marriage and also in death should I pass before my spouse. Currently, I am dating someone with children that wants to be married. So if you would answer how to protect them in marriage, I'll have Amy answer how to protect them in death.
Absolutely. So I think first and foremost, if you're getting married a little bit later in life, and I'm only assuming that because your future spouse has children, you have more assets to protect. You, I think, said you make more money than your future spouse, so you want to protect that income. And I assume you have been making more money for some period of time, which probably means you have assets. Maybe you have a house, maybe you have an investment account, your retirement accounts. All of those premarital assets, in my humble opinion, and I can't give you legal advice, but just in my opinion, should be separate very generally, right? When we're entering marriage at any age that is like over 22, you've probably earned some money. And that should be yours alone. That money was from your effort. Those assets were from your efforts, right? If because your spouse, let's just pretend you make $1 million a year and he makes, $2 a year, right? Let's make it really dramatic. If that's the case and you would feel more comfortable making things a little bit more equal, you could have a shared bank account. And you can actually contract to have a shared bank account in a prenup. And you could choose what you want to put in that account every month. Maybe you and he agree, and it's very hard in an agreement a prenup to agree to a specific amount, because what you don't want to do is agree to a specific amount and then not be able to fulfill it. So, most prenups have language in there to cover that. But you could choose to put in maybe $1,000 a month. Maybe it's just for living expenses. Maybe you share a checking account for living expenses and a savings account that is your marital money. And that marital money may mean you buy a car together in the future, or, you make yourselves feel like you're really in this together. And maybe he contributes some of his income, right? Even if it's less, you can do that. A lot of people do that. And that is probably by far and away the most common contracted to term that we've seen across the country, is having a shared bank account. And people will choose to contribute to that account oftentimes by percentages. So that makes it a little bit more fair if the parties have different incomes.
So I'm going to say one thing, Julia, and I don't know if you're seeing this more and more, but I am seeing more and more prenups that come to me where the incomes are separate.
Yes.
The assets are kept separately. There is a joint bank account whereby they pay the marital expenses. But at the end of the day, what's mine is mine and what's yours is yours. And unless it's a jointly titled asset, that's going to be the way it's going to be. And then the jointly titled assets would be items that you both agree will be jointly titled. Now, of course, the issue for that is that if you become a stay-at-home mom, right, and you're not out there working and building your career, then you are going to be in big financial trouble. And so you really have to think out before you sign that prenup. And by the way, some of you may have children who are going to be getting married too, right? So you have to really think about what that's going to look like for the plan, the bigger plan. It is transparent though, right? It's, what you're getting into. And I think that's important too, right?
Yeah. And I just want to say, I think that it is so common this day and age for people to keep everything separate, to the point where, there are some people who they don't even want a shared account. I think you should probably have a shared account if you're going to be living together. I mean, it's just practical. And most people I think it's like something like 75% of HelloPrenup couples keep everything separate and have one shared bank account, or maybe one shared checking account and one shared, savings account. So that's really common. Another thing that's really common, and you might consider thinking about, I know Lisa doesn't love these, but a sunset clause.
Hate those.
Which says that at a certain anniversary or specified date you choose, the prenup is void. It's gone. It's like it never existed, right? And that doesn't necessarily mean that at that date everything goes 50-50. It just means it defaults back to whatever that default state law is. Again, this can vary depending on what the provision says. But generally, a sunset clause is great in marriages where, you think you want to combine more, but you'd like to wait 10, 15, 20 years first, and make sure you're really comfortable. And it gives a sunset clause gives you that leeway.
It does. It also lets people stay in the marriage for a really long time, or at least until the sun sets, and then all of a sudden,
or get divorced,
right?
Or get lots of Hollywood marriages. You're like, they all get divorced at year 9 or year 19. Like, I wonder why.
Julia's right. I'm not a fan, but I do see them, and I understand people like to do them. I think that people can actually not have it, but instead make the decision later, right? Now, it's an interesting thing. They can't just tear up the prenup. and say like, no more. Okay. So it's really important that if you're going to decide that your prenup is no longer going to be a prenup, that you don't just all tear it up, because I promise you some lawyer will have it 10 years later and it really will be a prenup. And so, or there'll be another copy of it out there. So you really need to go back to your attorneys if you want to void out the prenup, and you didn't have a sunset clause, and make sure that there is a revocation of the prenup, properly done, acknowledged, and signed the way that the state requires, because ripping it up doesn't really help. Like, you could have that big ripping up champagne party and then it's not really real. So, Amy, tell us how in a prenup you can protect yourself in death.
So people are often surprised and don't think about the death aspect, which is to say, for example, in New York and in most states, spouses have a right to a percentage of your estate. So in other words, you can draft a will or a trust and say, I'm not leaving anything to my spouse, but your spouse still can get, for example, in New York, a third, generally speaking. You can, in your prenup, say, actually, no, I don't have to leave a third to my spouse. I don't have to leave anything to your spouse. That doesn't mean you're prohibited from doing that. So it gives you the complete flexibility of saying, I don't have to. At the same time, if we're married for X number of years, I could leave something to my spouse. I could leave assets to my spouse in a marital trust. This is particularly important with wealthy families when you're doing planning, because if someone's parents have assets, you certainly want to say that they don't necessarily go to your spouse. Maybe you want them to go to your children. Maybe that you want them to go to your sibling to keep that within the family. I mean, you could break up a family business by having to be forced to give something to a spouse. If you die and an asset goes to your spouse and your spouse gets remarried, then maybe your children unintentionally get disinherited when that spouse dies. There are lots of things that happen with a prenup that have nothing to do with anyone getting divorced. It has nothing to do with anyone having bad intentions. It does have to do with if you think you don't have a will. I think Lauren said that, like, the government has provided for you, right? I can't remember if it was Lauren or Julia, but the government, it's the same thing. Whether your rights are provided one way, and your rights, the paradigm upon which your rights are in the estate context are everyone gets married at 20 nothing and is married forever. And that's what we're going to protect. It does not look at people getting second marriages, people getting married later in life, one side having children, the other side not. I mean, so the fairness of these laws are really based on a very simple situation that was very common years ago and is not so common for many people now. So the prenup does absolutely protects that, and should. I mean, I think we've all sort of danced around this idea of having these conversations with a spouse, maybe, or future spouse, may be difficult, but if you can't do that, it's not going to get easier during marriage.
So Lauren, actually, could you speak to that issue of how to have that conversation, when to have that conversation?
Well, absolutely. I'd love to. And to Amy's point, you're either going to talk about it now or you're going to talk about it when you get divorced. So I'm on the fence and in the camp of talk about things ahead of time, because one of the symptoms of going through the prenup process is, even if you decide this prenup isn't for you, one of the things that's going to happen is you're going to learn to bring up tough topics early with the party or your partner, and inevitably be able to stick up for yourself. One thing that I experienced while going through that process was I didn't get the opportunities to stick up for myself because I wasn't really prompted with awesome ideas that Lisa, Amy, and Julia are presenting here. And so I just encourage everybody to feel really empowered through the process. And to make sure that, again, you're asking, like, how does this benefit me, and doing that early and often, because otherwise you go through the divorce process, which I've also had the joy of going through. And we used a mediator to do that. And basically all of the conversations I didn't have in my prenup process, I ended up having in the divorce process, which is a very similar experience. Instead of collaborating, at that point, you really are negotiating because you're talking about all of the things that you didn't get to talk about in the very beginning, but there's a lot more at stake. And emotions are high. You're not on the honeymoon, fairy tale, happy marriage bliss where anything you want, baby, I'll sign anywhere. You're now in, I want to get away from you mode. And so you're more in a state of mind of I can't think as clearly as I'd like to. And so it's harder for me to have really constructive conversations with you to get to what's important for both of us. And you're going to be energetically drained. So I just encourage you to have those conversations within a prenup, at least go through the exercise of asking, how does this benefit me? What other ideas do we have to make me feel safe in this marriage? And inevitably avoid the painful divorce conversations. But either way, you're going to have tough conversations. So have them early and often.
So I'm going to do two things. I'm going to answer the questions in the chat, and I'm going to put in a plug for the new podcast that Savvy Ladies is coming out with, because how does it benefit me is part of the power of the ask. And Savvy Ladies is launching, I think in about a week, actually, a new podcast called The Power of the Ask. I am hosting it with one of the other Savvy Ladies board members, Precious Williams. It is an incredible podcast. We've already interviewed, I think, 5 different women with interesting stories and interesting narratives about their lives and how they built themselves in the world of finance. And so it's a very interesting podcast, and you should all tune in. We'll send actually something out when it launches. And now I'm going to go to another question, which I think is a great question. I feel like my scenario may be a little different than the average one, but would love any advice. Basically, there is an income disparity versus a net worth wealth disparity. So this person makes significantly more than her future husband, and he comes from a wealthy family. So he's going to have a lot more assets overall, but she's going to have a lot more income during the marriage. And she is concerned, as I gather this, that she'd be losing 50% of her own income or the assets that are accrued through marital assets. This is like a prime person who should have a prenup and who should be negotiating it, and who should make sure that likely, okay, a large amount of the marital assets, do you agree, Julia, should be kept separate? And because somebody's going to end up with essentially inheritance and half the marital assets if we don't do that.
Yeah, I mean, I would say that all of her assets and income, I think I read this question very quickly, but she's worried about her income being kind of sucked up for marital purposes, right? You can keep that separate. If you dictate that you are going to have a separate bank account, you put your income in that separate account, and you state in your prenup that you want your income to be separate, and alimony is waived, right? You can keep your assets separate. And I think, in fact, you should. And then, of course, I mean, trusts get very complicated, and that's why we have Amy here. But my experience in divorce law is oftentimes trusts will throw off distributions. And if that's the case, then maybe you can agree, as I said before, you have one joint bank account and only a certain amount of money is put into that. But the lion's share of your income and your assets remain separate. And then if you do buy anything together, that should be money that comes out of your joint account. If you want to, let's say he doesn't have the money to buy a house, but you want to, that house that's being purchased with your marital money should be separate. If you decide to, I always, joke, if you go decide to buy a yacht, that yacht should be separate, right? So ensure that your assets remain your assets.
I'm going to quickly go through these other questions because they all deserve to be answered. They're all fabulous questions. So I'm going to take the what I think are the easier ones first. How would one approach a prenup for a second marriage? I think we've kind of already talked about that. If one is older / retired, I think that, again, you may want to consider keeping assets separate. You need to figure out how to protect the assets that you're coming in with. Maybe you've gotten divorced, maybe you're widowed. I don't know what the circumstances are, but if you have assets, make sure, particularly in a second marriage, that you are protecting those assets, and make sure that you are bargaining for what you will need. I think that question, how will it benefit me, is my new question, actually. And it's a great question to ask. How will it benefit me? I'm going to go to sleep at night thinking about that question.
It's a good mantra.
It's a great question. So I think you really need to find an attorney who can actually advise you on your specific circumstances. This one is very complicated. A spouse barely put me on a trust after 17 years of marriage. There's no children in this. It seems like the prenup may have already been set aside. Good for you if you were able to do that. It's hard to do. But there's also, it sounds like there's a trust of some sort. And the question in here that I think is important, but isn't a trust undone if divorced anyway? Not necessarily, right, Amy? It depends on the trust. So it'll depend
if it's revocable, you can undo it at any point. If it's irrevocable and it can't be undone, if it's irrevocable, there may be a clause in there that says my spouse is out if we're divorced. So they still may be out, but yeah, it's a nuanced question.
So I think you need to, right. And I see that you have no power to get other representation. I think that there's a couple of things you need to do. One, you could call the Savvy Ladies Helpline and see if there's specific questions that you have about your finances. They may not be able to answer these particular questions because you may need an attorney. So I'm kind of giving you the heads up. If so, maybe there is, if you're in court, you may be able to get a pro bono attorney. If your spouse is wealthy and you are not, you may be able to move for legal fees. So there are various things that you can do. Do not give up. I would say that. Do not give up. If there is money on the other side and you've already got your prenup set aside, do not give up. It sounds like you're, if you've gotten that far, you're doing really well and you need to get to the next spot there. And so don't give up on the challenge. What does it mean to have two-party names on a house title as a trust? Amy, I'm going to turn it to you.
I'm not exactly sure of the question because it says two names, then it says a trust. So what I think the question is that there's either a trust owns the house, and that means whoever the beneficiaries of the trust are own the house, controlled by trustees. Or it might mean that you can put two trust agreements on a house. So we frequently have, like, husband has a trust, wife has a trust. The house is owned by each of their trusts 50-50. In New York, if it's husband and wife, generally the default is rights of survivorship if it doesn't say otherwise, and it wasn't an ancient deed.
So one of the questions I answered for somebody, they should not give up. I'm just going to tell you, it looks like you've set aside the prenup. I see the next portion of this. There's too much in assets to give up, so don't give up. It may take a while, and you may have to really be in it to win it, and so you may have to just fight your way through it. And I think that that's one of the things that we all know is that stamina is half of this battle. If you get worn down, it's not going to work. A lot of it is stamina and staying power. And I know that's hard, but that is a big part of this, unfortunately. There is another question in here that I'm going through a divorce, which I thought a prenup would protect me, but I found prenups can be thrown out very easily. If a person lies, the prenup can be considered invalid. So Julia, what's your feeling on this? Because I don't find that they can be tossed out easily, unfortunately, sometimes.
Yeah, I mean, I think it largely depends on what state you're in. I think it largely depends on the facts as well. I think most states, and especially in recent years, are really pushing forward with upholding prenups and upholding the terms that the couples contracted to. Again, it depends on circumstances that can be very specific. I think judges are really careful about upholding prenups in a case where one party would be left with absolutely nothing, absolutely destitute, because that is against public policy. So if I don't know the specifics, but if that is the case, then it makes a little bit more sense. But otherwise, I just don't think they're that easily thrown out.
So tonight's session is going to come to an end. Unfortunately, we thank Amy Holzman, Julia Rodgers, and Lauren Lavender for their support. And of course, savvy ladies, you all should use that free helpline to the extent that a financial advisor or a professional can actually advise you. Believe me, savvy ladies is great. I also encourage you to listen to the Power of the Ask as soon as it launches. The stories of the women that we have interviewed are truly inspirational. I will say they're really incredible women. And as we go into Women's History Month and Women's Financial Literacy Month, I think that we should all listen to many women's stories to get the inspiration so that we can actually make the best decisions. And again, ask that question, which is, how does this benefit me? So good night, ladies.
Thank you.
Thank you all.
Good night.
Everyone.
Thank you
Good
so
night.
much.
Thank you so much.